We're back, as promised, with another episode of Gatehouse Insights. In this episode, I'm finding out about workplace culture, leadership, flexible working arrangements, and more. We are also taking a look at the challenges facing organisations in light of the metoo movement and how a workplace should handle employee complaints. I'm joined by my guest Sarah Rye, Managing Partner and Co-founder of Justitia. So you're the co-founder and Managing Partner of Justitia. Tell us what made you start the practice and take us back to the start of your legal career.
Well, every legal career, I guess, starts with a law degree, and when I started out I had no idea what I wanted to do. I was fortunate that in addition to my law degree I was also studying arts and I was involved in student politics, but it was actually one of my arts subjects that sort of started me on a journey around being interested in organisations. The subject was called political psychology, it was part of the politics department, and we were studying about organisational leadership and the types of leaders that are appropriate for certain types of environments. We also were interviewing leaders and CEOs, and I was already then learning how to interview people, and little did I know that that might stand me in good stead later in my career. So there I was in my law degree wondering what I might do with this generalist degree and had no idea really, and followed like a sheep putting in applications for summer clerkships at the time, and out of my 10 applications there were 3 interviews and only one opportunity to do a summer clerkship, and fortunately it only takes one offer, and the offer eventually led to a offer of employment and article clerkship at Dunhill Butler, which was a national medium-sized firm, and I was very fortunate to land with that firm because it was a very special firm. And it was special for a number of reasons, and I think I can still remember actually the interview with my managing partner at the time. Actually he was a staff partner, he then became managing partner. He could tell, I think, from that interview that I enjoyed a robust environment and that I might be drawn to an area where there were sort of loud, colourful personalities. And so I was placed in the employment law team of that firm, and the team actually had 2 preeminent lawyers in it, being Stephen Amendola, who's a well-known and highly regarded employment lawyer and litigator in Melbourne, and the other person was Jonathan Sandler, and he had immigrated from Cape Town and had a background of having worked with black trade unions and had a great understanding of mediation and alternative dispute resolution. He was one of the early founders of LEADER. And so very fortunate for me, I had 2 partners in the practice who were emblematic of different approaches to legal practice. So someone who was well versed in litigation, the other person also well versed in litigation but with a very deep understanding of alternative dispute resolution, and both of them were very inspiring for me. And Jonathan in more recent times unfortunately passed away in his early 50s, but his inspiration continues with me, and in recent times I became accredited as a mediator myself. And so I stayed with that firm for a few years and was made partner at Dunhill Butler. And it was a time of change, in generational change around how legal practice operates. So they were the days when you could celebrate successes and write off an afternoon, and lots of storytelling. And I think that was a way that in which we implicitly learnt what it was to be a good lawyer and how to bring a great camaraderie in a team. The other thing that I remember from that time is that these were the days when the senior partners were called Mr. Walker, Mr. Elder. I don't remember any misses, I have to say, but having said that, it was usually just for the very senior partners in the firm, and that is a bygone era. We don't really, no one gets referred to as Mr. Such and Such anymore. And so really enjoyed that time with that team, and then around the year 2000 the firm was merged with Deacon's, and I and the employment law team decided to move, and we moved over to Blake, Dawson, Waldron, at being Ashurst, and I was a special counsel there. So that was the first major stage of my career. I guess the Blake's part was 4 or 5 years. That was the middle part. And then the next stage was really determining whether working in a large first-tier firm was the place for me. And there's a lot of things you do gain from working in a large law firm. You get to get a very good training, you get to work with good clients, very important work. The downside is, as a junior person, for juniors, you don't necessarily get as much hands-on experience, so that was why I loved starting at a mid-sized firm when I did. But there are also downsides in working in some of those larger firms, or there were certainly back then. So 15 to 20 years ago, there was certainly, the way you might describe some of those places was, you know, very hierarchical, bureaucratic. When decisions are being made on some new initiative, you know, there's multiple committees that have to have a say, a bit more inflexible around the way that one works. And so I'd been having that, actually I would also say a bit of a dog-eat-dog mentality around work and collaboration. So I was having that conversation with colleagues, peers, and I guess out of those conversations came a decision with one of those colleagues with whom I'd also worked at Dunhill, Madden Butler, to finally strike out on our own and set up our own legal practice. And really, for us, that was the opportunity to put into practice some of our ideas about how a law firm might operate, and whether we can actually forge a new way around client relationships, and how we set up work around flexibility with our staff. So that was our intention right from the start. And I do recall people wondering whether we were risk takers and whether we were foolhardy, and maybe they said that behind our backs, but we really thought, you know, let's stop talking about a better world, let's see if we can give it a go and see what might happen. So we had a very open mind about what lay ahead for us, and started off very modestly in a small office, and then things just grew from there. Would you like me to continue telling you about that story? Or?
Yeah, go for it.
Yep.
Okay.
So the first few years was all about essentially also being business owners, and no longer just being either an employee or a partner with little say about how the organisation operates. So we had to work out what our strengths were and see how we might work together with those strengths and make decisions about every aspect of the firm. And that's what drew us into wanting to work in that way, because it's such a varied experience. You're not just providing advice to clients, but you're also making decisions about marketing, finance, you know, staffing issues and all of that. So we started off small. We put a few things in place to try and experiment with different ways of working with our clients, and certainly sought to keep our overheads as low as possible, because we thought that the services that are provided in the employment law space don't really don't lend themselves, I should say, to the big end of town, charging large hourly rates to fix problems and issues, workplace issues. So that was sort of one motivator. Another motivator was that we very much like to work with clients to help them stay out of court and to find alternative ways of fixing issues and problems. And both of us, I mentioned the influence of Jonathan Sandler, we both had a strong interest in ADR and mediation, but even further than that, having an understanding of how to find alternatives to allowing conflicts to either fester or escalate, and how to keep, as I said, keep clients out of court, which ultimately is what they're after as well. But it does take a lot of skill to achieve that. And so Mary Jane, I know, also was trained as a mediator early in the piece, and a lot of our reading at the time was along those lines. So we were trying to look at what are the alternatives around keeping our clients out of court, also trying to train our staff to think differently about the issues that our clients were coming to us with. So to think much more broadly around the advice that they give, rather than just expecting that when the HR director or the CEO or the manager comes to us for advice, that we're not just going to give them legal advice, but we are also going to think about the range of competing obligations and issues that they might be juggling at the time, and putting the legal issue into a broader context that we know that they're grappling with. I think lawyers typically are trained just to think about issues from a legal perspective and about risk and cases and drafting case law, when fundamentally the client is, you know, yes, that is an issue and they need to know what the risks are, but that's not the primary driver for why they ultimately might make the decision that they do. So in those early years, some of it was about retraining ourselves, but then also trying to retrain our staff to have a broader skill base and be able to coach the clients around dealing with issues in a slightly different way that might head conflict off at the pass. And I think I can illustrate firsthand how that shift happened for me personally. So whilst I had been a partner in the medium-sized law firm, I only really felt truly like I was a manager of people when I set out with Justitia. And when you manage people, you also have to performance manage people from time to time. And I had unfortunately had to have a couple of encounters with people where I had to have those difficult conversations. And lo and behold, I found when I was having them myself that they are actually really stressful and highly emotionally charged experiences. And I had been advising my clients about having those conversations for 15 to 20 years before that, and done so with great confidence, but actually never had that sort of conversation myself. So that was a revelation and has fed into my general approach that I was talking about coaching the HR people to have those conversations more effectively. And it makes me a better lawyer as well, to have experience as a manager of people in my practice. So Justitia has been going now for 13 years, and Mary Jane Diakonu and I had worked together since the days of Dunhill, Madden Butler, and it has been a very successful partnership. We were profiled in a book, as it happens actually, by a woman called Nora Breakfeld, who's a management consultant. I don't know if you've heard of her, and she's about to launch her third book, but her first book was called Sideways to the Top, and it was about profiling a number of women and their careers, business careers, and just describing the twists and turns that can occur and the varied paths, a bit like your interviews with many lawyers, the varied paths that it can take to get to your dream job. And so in that book there's only one chapter describing two people, and that's Mary Jane and I. We were described as the yin and yang balance, which was a pretty good description of us. So that was in 2013 that book came out, and I guess that was sort of the start of people learning a bit more about what we were doing and why we were doing it. In that same year, Justitia was named Law Firm of the Year by the Law Institute of Victoria, which was extremely exciting, and the criteria at the time were, you know, issues around excellence and innovation and standing out, I suppose, from the pack around the way that one is running one's practice. And we were glad to be judged Law Firm of the Year amongst our peer group. Then the following year, as it happens, we won another award, which was awarded by ARI, so the Australian Human Resource Institute, and that was called the Sir Ken Robinson Award for Workforce Flexibility. And that was even more exciting in a sense because the pool that we were being judged against was all businesses in Australia. And I think why we came to attention was that we were trying to create this different type of flexibility in working in a professional services firm. And I'd love to talk a bit more about that at some point, but because I think the legal profession is dragging its feet in this space when you compare us with other professional groups such as the accounting firms, and you know, there's a lot of work still to be done. But back in 2014 we were receiving the recognition for that. And then more recently, just last year, I think we did receive recognition for our website, and I mention that as well because as most people who are involved in running businesses, the messaging that you put on your website is very important and forces people to synthesise really what they're about and what's important to them. And so we tried to do that with what we have on our website, and it's moving beyond, I think, what other law firms and employment law practices say about themselves, because we are interested in creating workforces and workplaces that work for everybody. And as an employment lawyer, we're interested in that, and we really wanted to get that message out as we work with our clients to improve what they do, and because we know that's what their priority is at the end of the day. Their priority is not, you know, having the oldest law firm in town telling them what a particular risk is, but they want to collaborate with people who can help them be the best type of organisation that they can be.
Because you're a big believer of leadership, mentoring, coaching, developing your employees. Tell me a little bit more about it and why you see it so critical to a business.
Well, first of all, I think it's important that when you are advocating to your clients how they should do something, particularly around best practice and managing their staff correctly and ensuring they put the right people into various positions in their organisations and adhering to their own values. In doing that, you need to practice what you preach and make sure your own house is in order. So I think it's really important that we make sure that our organisation is doing all the things that we're advocating to our clients. Then I also mentioned, I think that it's important to stand in the shoes of our client, to understand what are all the pressures on them around their decision making, and understanding that better. So that helps us provide the right advice for the client. But what we have also found over time, I think, is that lawyers can allow their work to grow in a way where they're just putting out fires on behalf of clients. So they might receive one claim after another claim after another claim, and they'll just readily help the client defend the claim without stepping back and saying, actually, there's a systemic issue here, maybe we need to do something about this, and opening up that sort of conversation. And the reason why I mention that is because, yes, from earliest days, from university days when I was studying this political psychology subject, I'm interested in what makes organisations tick. And HR departments are really the professional caretakers for how an organisation operates. And they're responsible for all the various levers, or overseeing the levers and advising the CEOs and the managers about the best way to create a productive workplace. And so us as employment lawyers, we're there to support HR. And so I guess the issue is about, a particular interest is around workplace culture, and this is a term that we're hearing increasingly a lot more about, particularly I think in the lead up to the decision about the Royal Commission into the banks. So a lot of it has been about talking about culture in banks. And likewise, every organisation has a particular culture, and there are levers to influence culture, and there are also ways in which to determine whether the culture is struggling. And again, it's all about getting lawyers to understand the language of what those things might be. So organisations have surveys, for example, to check in on engagement surveys, how people are feeling about the organisation. But there are other monitoring tools that one can look at to determine whether there's something rotten at the heart of the organisation or not. And I'm talking here about assessing things like, you know, levels of sick leave, special leave that might be taken, claims being brought internally, claims being brought externally, confidentiality agreements for exits, all of that. And HR departments are generally aware of those things and are managing those things, and they're usually indicators of whether the organisation's functioning well or not. And there are organisations that are highly productive but might have a really poor workplace culture. And I guess my thesis is that you might still achieve the productivity, but you'll have a fallout in other places that are often hidden, and it's about asking the right questions within the organisation, whether it's the board that needs to be asking those questions or whether the CEO needs to be getting the right data from the HR department. So we have been doing work in this area. We've been helping organisations do reviews of either whole of organisation reviews or just of teams, looking at whether there's dysfunctions occurring, what the causes might be. Often the causes can be to do with bullying cultures, for example, and that's often due to individuals, whether they're in a senior role or a mid-level role, and it's about identifying those people and doing something about it, because as I mentioned, the cost can be quite significant. And the reality is there's a lot of people doing, say, workplace investigations around town, and probably 80% of those are to do with bullying allegations. So if you actually quantified the number of investigations and the costs involved in actually just dealing with those issues and those complaints, it would be quite horrifying, I think. And so how do we spend less resources on putting out fires, and how do we put more resources into creating, you know, great workplace cultures and great organisations?
How does a company change its culture?
Well, the first thing they do is they make sure they've got the right person at the top.
Okay.
And if they don't have the right person at the top, you can forget everything else.
Okay.
And so there's good leaders, there's average leaders out there, and, you know, in a private corporate setting, it's up to the board to make the right decision about the leader that they put in place, and the buck stops with them in that regard. And if they don't get that decision right, then it's very difficult for all the people working under that leader to do their jobs properly. And, you know, you work in recruitment, and possibly you get asked from time to time about what is going on in an organisation or what the culture's like, and perhaps if someone's unhappy about the culture, you know, either things are going to change soon or they're not, and people then vote with their feet and they leave if they don't like it. So how do you change it? You look at who the leader is, and you continue to performance manage that leader, and you also assess the types of leaders and people that they've put under them to ensure that they are also doing their jobs and are being properly performance managed. And you make sure that you've got a succession plan in place as well. So a healthy organisation will have a clearly articulated succession plan, and a healthy organisation generally will have one or two talented people who may be prospects for leadership and stepping up if that was required. Now, it may not necessarily happen, but that demonstrates a leader who has such a great leadership style that they can manage and they can empower very talented people under them, and potentially are not afraid of having talented people who are actually better than them in certain aspects of their jobs. So everything flows from there. That answer is very dependent on the size of the organisation and the industry, and different industries have different requirements and needs. But certainly, again, coming back to this subject that I did at university, you know, it was all about understanding that different types of organisations require different leadership styles, and the challenges come where you have a mismatch potentially between the leader and the type of culture and structure. So a military organisation needs a different type of leader to, say, a political party and the type of leader they need, or a religious organisation needs a different type of leader. So it's understanding those dynamics. And then most well-versed HR people also understand all the levers around culture and different types of cultures in different environments, and what's needed in a sales environment versus a professional services firm, that type of thing.
Now, moving on to flexibility within the workplace, from where we sit, there is so much talk within the legal profession about flexibility, but then the feedback we get from our candidates, they say, yeah, our firm has this flexibility policy, but it means leaving at 4 p.m. That's as far as it goes. First of all, what is your definition of flexibility?
Well, my definition is really related to something that you wouldn't necessarily see in a policy, which is ultimately that someone will come forward with a request of either their manager or their organisation to work differently. And that might be that they want to work less hours, or they might want to work in a different place at some point of the week or for all of the week. And they'll have all their reasons for wanting that. And then the organisation's ability to accept that request is that they need to be satisfied that the person's still carrying out the role they're required to carry out, that they're being remunerated appropriately, and that all the various supports are in place to make that arrangement work, and that the person's not going to take advantage of the situation. And so yes, there are special requirements in the Fair Work legislation about what employers should be doing in that space, but really we're moving so much more now with the introduction of technology to a much more flexible mindset about how work can be carried out. And we need to ensure that policies are not just beholden to organisations that do it well because they've got very enlightened management versus those organisations that don't do it well because they're not. Or even within an organisation you can have a team that's well known with great leaders who can just accommodate flexibility versus those that don't. And that's unfair in a sense where you do have all those variations in an organisation because people come forward with their request for flexibility, and it's quite an arbitrary response that they're getting from the organisation dependent on the skills or otherwise of the particular manager. But I think it's important for there to be a give and take in the employment relationship, and managers need to be able to performance manage and manage a person well, and they might need some support themselves in doing that because sometimes these things do go off the rails. But in doing that, you're showing that people go through phases in their lives where they're going to need different things out of their work. And if you want to keep them motivated, and if you want to have a dynamic working environment with different people doing different things, if you do flexibility well, then you're going to, I think, have a much nicer and better and more effective place to work. And let's face it, people make those requests for flexibility for all sorts of reasons. It's not just children. We're seeing more people wanting flexibility to deal with their pets, for example. Ageing parents is another group. People might be pursuing academic endeavours, they might be comedians, they might be sports people, and I think that if you encourage people to follow their passions, they're likely to be more passionate about their jobs as well. And you know, there are challenges. So the challenge for working in an organisation where you're in a senior role, for example, you might find there's more resistance for the organisation to want to support the flexibility. But I think it should be there should be a very open mindset by the organisation and the managers to that conversation about how do we make this work for both parties. And there's certainly been a lot of discrimination cases that have fought over, you know, a senior person's role and whether they can do it flexibly or not, or more unreasonable rejection of requests for flexibility. And it's better to stay out of the courts in these things and to find a middle ground, or to even trial an arrangement and see how that goes, and then come back to it and talk further about what needs to change to make it work for both parties. And so we have a variety of things that we try to do at our firm in this space, and as I mentioned, have received some recognition for it. We have what we call a presumptive model of flexibility, which means that we would anticipate that every person comes in with wanting some flexibility of some sort in terms of how they practice as a lawyer, and so we need to work out how we can make it work around the measures that we put in place for the individual. And likewise with our clients and flexibility, drilling into the basics, I suppose, of how we make that work. We always have clients, when they get introduced to the firm, meet at least 2 people in the first meeting, and we don't charge them for 2 people, we charge them for 1 person, so that they have 2 contact points in the firm. They will generally then be assured that both people are across the broad issues of that particular client, so that they have a very responsive approach from us when they ring up, because the reality is no one's ever available 24/7 for any client. So there will be always someone that can deal with their issue and is generally in communication with the other person, and the information has been shared. And so the clients really like that, and we've been working that way now for 13 years. We also would say that it's not easy working flexibly. It's not for everybody. It takes, again, a pretty flexible mindset towards work. It takes very developed communication skills, and in certain settings, such as in a litigation setting, you know, one just has to work effectively with another person, and that's not all the time, but it might be given a particular matter. But ultimately, the bottom line is what's in the best interest of the client, and so decisions are made and the sharing of the workload occurs in accordance with what's in the best interest of the client. In terms of working in a smaller setting, such as ours, there are also, and probably in larger organisations as well, some of the downsides are things like you know, having an empty office for someone who's not there for the full week, and that's, I suspect, why we're moving more to open plan to facilitate flexibility, or having subscriptions for people where they're only working 3 days a week, and so in a smaller organisation that is a greater burden on the business for doing that. But I do think fundamentally the trade-off of longevity of staff and goodwill, and people putting in the extra mile, and we do require, through our conversations, people tend to want to make the situation work, and so we'll have agreements around communications in the office about how people want to be checking in on their emails and that sort of thing, or how they want to be contacted, and all of that just gets agreed between the individual and communicating with our reception and with the lawyers that they work with. So we find that that works for us very suitably. And I mentioned before that, you know, the legal profession seems to be dragging their feet in this area, and I say that in contrast to accounting firms, where in, you know, the last 1 to 2 years they have made public their policies where really it sounds like it's optional as to whether you come into the office. They expect people potentially to be on site or accountable to their manager, and where they do their work is a matter for them. So some of those people obviously are not litigators in accounting firms. They don't have to be at the courts all the time. There are environments, well, there's pockets in law firms where the team should be working together, or M&A, and, you know, work that is highly pressured, requires 24/7 sort of working together as a team. And I guess all I would say in those environments is that they should be much more upfront when they're recruiting, to communicate to their young staff that this is the way we work and this is what we're going to need from you when you get to this stage if you want to work in our department. And there are sacrifices that need to be made, and that's just the way it is, and you get paid accordingly. I think that's really important. And then I think there's also slowly perhaps a recognition that there's different ways that you can engineer work and project manage work in a way that enables people to be working more effectively in teams, which doesn't involve people burning out. And I would suspect that that is an ongoing problem in our profession, and we have people who leave our profession with, you know, serious mental health issues because of the burnout from these environments where the pressure's just been so intense for a long period of time, involving very long hours. And ultimately long hours are not indicative necessarily of someone being a good practitioner. And I guess I should throw budgets out there as well as another topic that does come up when one talks about flexibility.
What happens there?
Well, and this is probably one of the challenges, but I think we're in a transitional time as law in the law, and whilst I was describing what I hope is now some of that poorer aspects of large firms from the past, with technology we're seeing the way things are done is changing and becoming more flexible. And so the issue with budgets is that lawyers I'd sign up to working what they might think is a normal working week, But in a medium to large-sized firm, in fact, the unwritten expectation is that you're working very long hours, and to be successful you have to work very long hours, and that you're probably paid well to work very long hours. And of course, if you work very long hours, then you can probably meet all the targets that you need to for budgets. And this is just the way law firms are currently, most of them are currently set up, which is to monitor people very closely around how many billable hours, how many non-billable hours, all the other things that they're meant to be doing around, you know, admin, marketing meetings, etc. Very demanding. And I think that for us and budgets at our firm, that we will monitor people's time, because our systems do that, because we have to bill people at the end of the day. But we just use the billing information as a guide for a conversation about what people are doing with their day. Because it's always been a founding principle of the firm since day one, really, that it's our responsibility to keep our staff busy, either on billable work or non-billable work. And often lawyers do need a lot of guidance about what to be doing to build a practice if they're not doing billable work, and they do lack, there's a lot of, they don't get taught that at uni at all. And so budgets seem to be still inherent to big firms, even though there's pressure from the marketplace for fixed rates and fixed charges and fixed estimates for work, which is also challenging for firms. But I would suspect that with the many people that you've interviewed, particularly the ones that have moved out of private practice, the first thing that they will say is, it's so great not to have to track my time and put in my sheets for billing, and so isn't that interesting? And if you probably asked most lawyers what their bugbear is and what they don't like about their jobs, it's tracking their time to such a degree and having that being hit over the head with it when things are not going the way that they should, when ultimately it is an indicator of something, and the question is an indicator of what? The person might not be suited to the job, the person might not be in the right department, maybe the person should never have been a lawyer. How upfront are we about these things when we attract people into the profession and into private practice in particular?
Well, I don't think they're aware, or they're I don't know.
The young people who come in, they don't have any idea.
They have no idea.
They also have no idea about the high level of administration involved in a job as well. And I bring that up because, as you might recall, we've since day one had this program of legal research assistants.
Yes, tell me about this, because I'm very interested in that.
So we call them LRAs, and this was introduced from the beginning of the firm. And it did come to us actually from the Victorian Law Foundation. We heard that they were employing law students, and I don't think it was happening much at the time, but I have noticed in the last 10 years that law firms now are actually taking on people that they're looking to offer traineeships to early on to do administrative work within the firm. So I think we were a leader, a pioneer in this area. So we have a very well developed program. We have about 5 to 6 law students on our books at any one time. They work as a team, they self-administer their roster. There are 2 on every day, split shift, and they can do everything from answering the phone, filing. Research is the most important task that they undertake. They understand everything about our office administration system. They do the billing at the end of the month. And so they get this amazing training about how does a law firm operate. And I was laughing, talking to someone who's just started with us, who comes to us with, having done a prior job before doing her law degree. And I said, oh, you know, that I don't think these young people understand how much admin there is involved in being a lawyer, and maybe that's quite a surprise to them, because that can be quite tedious at times and we need them to do all of that work. But they understand then how things operate, how giving advice, tracking your time, billing it to the client, not billing everything to the client, what's the value to the client. They get to understand all of that. We give them good training, we support them even around some coaching for their interviews with their prospective employers, help them understand what networking is about, and we have this wonderful youthfulness in our office, and they all come with different skills that they have. Some of them have very little experience at the beginning but then develop in the role, and they don't all go on to employment law, but quite a few have, and in fact our first LRA ever is now a partner at Allen's as of last year. So, yeah.
When did she start with you?
So she started at either 2005 or 2006.
Now, touching on the Me Too campaign, can we dive deeper into it? Tell me what's it about? What are the issues underlying it? How can we prevent sexual harassment from happening in the workplace, and how can we get people, I suppose, talking and more comfortable talking about it within the workplace?
Well, Me Too is really in its infancy on one level in terms of that hashtag and the issues that originally were brought about by the articles in the US around Harvey Weinstein and multiple complainants against him. And it really has started, an avalanche is probably an overstatement, but it has resulted in an increased resourcefulness of complainants to raise their complaints and enhance and empowered them to think that they can think and actually raise their matters and potentially put them into the public domain. And so it really has changed the landscape for practitioners such as employment lawyers. And we're all, I'm sure, watching this space very closely. So there has not been necessarily any change in the law as such. There are some changes around the supports for people who go through investigation processes, but what has happened is this empowerment of people to speak out. And so the olden days involved someone making a complaint, everyone understanding that was confidential. The HR department looks at the complaint for a while and think, what do we do about this? Then they might ring their lawyers, and the lawyer says send it through, and the lawyer looks at it for a bit, and then they might make a decision about how they're going to handle it. But now it's like you receive the complaint, don't expect anything to remain confidential because it might blow at any stage. Depending on the bona fides of the individual complainant, it could be played out in the public domain. We have social media that allows information flow to go more readily. As soon as you've got senior people involved in the complaint, as in at the respondent end of the complaint, or where you've got multiple complainants, or you've got something suggestive of systemic issues in the organisation, then the organisation has some real issues. So the changes that have come about are that organisations have to be very responsive as a starting point to complaints when they arise. They need to now probably take a much more team-orientated approach, and they need to escalate things within their organisation to tip people off that something's come through that might have ramifications. They need to get their media people involved much more quickly. And the reason for that is just in case it might go beyond the borders of the organisation. And ultimately reputation is really important, and as much as someone might initially not be thinking about reputation, as soon as it becomes a bigger issue, sometimes the original issue isn't actually that serious, but all the damage that has flowed from the incident that's been poorly managed is huge, and they become names emblazoned in our memory, you know, around things that have happened in Australia. Either individuals become fixed, even though there might be no substance to it whatsoever, or organisations and the poor handling of a particular set of issues. So that's definitely changed, and we just can't be as complacent anymore. The other more proactive thing that organisations can be doing is reviewing where their hotspots are within their organisations around people where there's a cluster of complaints, or there's a number of people that have been deeded out and their confidentiality agreements, and why is that happening in a particular team. And whilst in the past the organisation might have been prepared to trade off the high performer for, keep them there but just pay off the people that are being offended by their behaviour, I think that that approach has to be reviewed in light of the various sagas that we've seen played out in the media. And then in terms of precautions, well, obviously having really good policies, making sure that people know what the process is, knowing who they can go to, and knowing that HR will be very responsive in dealing with the issues. And certainly at ARI, the Australian Human Resource Institute, there's a real conversation about their role as professional caretakers for the organisation, and when they receive a complaint, how do they deal with it and how do they escalate it? Because sometimes they can be put under a lot of pressure to deal with it a particular way which might not be in the organisation's interests, and they need to sometimes step up, and sometimes they need to make a really tough call which might involve their own jobs being on the line for whatever reason. So it's a very challenging time, but also a very exciting time for reawakening organisations to issues around poor behaviour, whether that's bullying behaviour or harassment or sexual harassment, because people are going to be called out about their behaviour. And whilst often when we have done our face-to-face training, it's all about saying to people, we are training you managers and we're training you staff with the whole intention of freeing you up to have these hard conversations when you don't like the way that you're being treated about something. It's really giving people, empowering people internally to tell you that I don't like the way that you just spoke to me, or I don't like the fact that you had a go at my accent, for example, or picking on my surname. And so it's about allowing people to resolve conflicts and issues and raising complaints at an early stage, and doing that through good training. But if the training's, if the person doesn't feel that they can do that, then going to HR, and not necessarily having this knee-jerk reaction that we have to formalise it as a complaint necessarily. Sometimes they're low-level issues and people need coaching to help them have the conversation, and sometimes they might feel really good about that because they've said what they didn't like and it's changed and it's not been repeated. And it hasn't escalated it to such a way that a person thinks that they actually have to leave the organisation because the relationships have been so, affected by formal allegations and investigations, and it's only going to result in an unhappy outcome. And so HR need to be nuanced in their handling, and they need to assess how serious is this, and in fact, should we be working on relationships, or does this team need more training, or should we just try a mediation first or a facilitated discussion before we then move on to something more formal? Because you do the formal process, but you actually still got the problem at the end. The problem hasn't gone away. If someone's not going to be sacked as an outcome of an investigation, you still have to decide what you're going to do with those two people in the workplace that have fallen out for whatever range of reasons. So it's complex, but I think that HR departments are going to be busier with all sorts of claims, and in fact, in our recent discussions with clients, they're definitely all receiving more complaints, not just about sexual harassment, but across the board, and people are feeling emboldened to raise their issues.
Even how small is too small?
What, in terms of what?
A claim or someone raising something like such as, he's picked on my surname or she's picked on my surname. Is that too small to raise it with someone, or?
Well, look, I think most organisations would say no issue is too small if it's caused you concern, because it's going to affect the way that you work with that person. But it's all about, do you need a hammer to sledge, to break an acorn type thing? What is going to be the appropriate fix for that particular issue? And probably in a low-level issue, it might be to say to the person, here are a couple of options that you have for dealing with this situation, and giving them some one-on-one coaching or training about starting off with the low-level, low-risk option and seeing where that goes. Whereas if they walk in the door and there's a bit of a history of poor sort of treatment by the manager, let's say, or a colleague, then it might need something a bit more interventionist. And it may be that that person is complaining, but actually there are others that have got complaints. Or if you raise it and you say to the manager of the problematic employee, oh, we've just had this complaint, and they go, oh yeah, you know, I've spoken to a couple of people and they're all saying the same thing. Well, let's do something about it. There's a problem there. And sometimes people that don't join the dots together as well as they should or as quickly as they should, and they have to do it more quickly now.
So no issue is too small because it might be happening.
Yep, there could be a systemic thing, and really it's about making people do their jobs better. How do we achieve that? And if that's the positive disposition with which you're going to have the conversation with the manager who's not got a particular skill set that's not working in some aspects, that's a much more positive way to have the conversation than to be talking about people are making complaints about you and we want to talk to you about it and we're not going to tell you who's made those complaints. Yeah. So it's tricky, and that's coming back to what I said before about we have to have some of those solutions. We need to coach our clients to have those conversations, and ultimately we want to have good and lasting outcomes. And sometimes you have to monitor the situation, and sometimes it's not going to work out, and then you need to know what to do, and you're creating a paper trail to exit someone eventually.
I wanted to shift the topic, and we spoke about it briefly, just in relation to women changing their names after they, I suppose, are married and after they have built a practice. What's your view on women changing their names?
Well, I think, I'm not sure whether it's a generational thing where there's been a period of time. I think I was a bit more in that era where that didn't happen, and then we seem to have a wave of where it has come back, where it is happening. And I guess I would be of the view that women should think very carefully about giving up their names, because they have been living with that name for a very long time and they have built up their professional profile and their careers on the back of that name. And if you're willing to give it over very quickly, you're actually wiping away all of what you have done in the past, certainly professionally, in one foul swoop. And I guess I think it's a good topic to talk about, because it's not talked about very much, and because it seems to be popular at the moment, and I'm not sure whether women have thought about all the consequences. And I would like to think that we are not living anymore in such a conservative culture here in Australia where it's seen to be something that has to happen. And you often hear arguments about, confusion for children, and how are we going to name the children, and if they've got a hyphenated name, what's going to happen after that? You know, the world's going to fall in. But really, the bottom line is coming to a view about a name for a person, and if the child has a name, hopefully they will keep that name. But do we have to have an entrenched system whereby every person has to have the same surname, for example? And I think we have moved on from that. You know, there's lots of diversity around names, and perhaps it's something that's peculiar to our culture as well, because in some other cultures, everyone has a different name, for example, every person in the family. So I think it's useful to think about these things early on, just like it's very important to think about these things when you're choosing a partner in life and you want to have a full-on professional career. You know, how logistically you're going to make everything work, and are you aligned on values, and what are your values around names, for example. So I've been lucky that I haven't had to have any challenges around that particular issue. I've kept my name. My children, again, I think fortunately have got hyphenated names. So I would suggest that there's virtually no one else in the whole world with their name, because it's two different names being brought together. And, you know, they'll face some challenges when they meet the next person, but they'll just have to work that out. And one of my daughters has a friend who's got three surnames, you know, three names in her surname, which is an amalgamation of a hyphenated name and the other partner's name. So
it's an interesting topic.
Diversity.
Yes. interesting topic, and we see a lot of women change their names. We also see women that don't change their names, so it's good to get someone else's viewpoint on that topic.
Yeah, well, I think they should definitely think about business profiles and reputation when they make that decision.
And before we wrap up, what's some words of wisdom you'd leave our audience?
Well, I think that I hopefully have demonstrated that there's different ways of looking at employment law practice, and one of my strong personal values, which I have, again, and with Mary Jane, we've highly valued, was in addition to promoting flexibility, that we also promoted people being active outside of their work, because we think that that informs them as being good practitioners. And it's also linked back into giving back into the community. And, you know, for me personally, and you've got to role model that, I think, for your staff. So if I give them latitude around pursuing their passions, that gives me the ability to continue with my passions as well. So, and also, you know, bearing in mind that some of us have benefited from a free education, so this is our opportunity to give back. And if you've done a law degree and you've got a legal background, you're valuable to organisations in terms of what one might be able to provide to them on a voluntary basis. And so my current passion has been the establishment of the Australian chapter of an American organisation called the Association of Workplace Investigators. And so I've been spending a little bit of time assisting with setting that organisation up for the benefit of all the people that are involved in workplace investigations and interested in them, which a lot of them are lawyers, but they're not all lawyers, and how to generally maintain the standards in that workspace. And we have conferences and we bring people together in local circles. So I guess my parting message is that with all the benefits that we gain from our professional lives and working in the law, very privileged, that it's also important to give back, and by doing that as well you might be acquiring skills, insights and contacts that can help you with your professional life going forward.
There you have it. That is the end of this episode of Gatehouse Insights. Make sure you subscribe to the Gatehouse Legal Recruitment YouTube channel, and you can explore the wonderful world of the legal profession. Thanks for watching, and please leave your comments in the box below.